Ne bileyim Roşun. Roşun aybetme Roşun for listi bunu IMI from Gallup for grade minor. On Wednesday.
On?
Wednesday one.
Okay.
What?
Wait, please, Your Lordship. I pray for adjournment item number 14. This Angus DLSA Council could not appear before this honorable court due to some personal problems.
You wait. No, this condonation will allow.
Not supposed.
Just wait. We will record your name. Or we'll record no one's name. Okay, yes.
What I wish to mention for listing on IA for continuation of delay in a matter appeal.
Okay.
Wednesday.
Lordship, in this case, I have checked up the record. Lordship, notice was served on the respondents. They didn't appear there. We were allowed to,
Newspaper publication.
that it will be accepted, Lordship.
That will be accepted. Now what to do? What is your case?
Now, my case is, Lordship, initially there was an assessment. Thereafter the.
In your favor.
Yes, no, Lordship, because
Against that.
it was in favor of the department, against the SSC. But, Lordship, with regard to two companies, they didn't file any addition. Thereafter, the matter was taken up by the PCIT under section 263. Then order was passed and it was remanded back. Then Lordship again assessment order was passed. That was challenged before the tribunal. Tribunal said that Lordship, but the tribunal has not considered section 223, 263 order passed by the PCIT.
I do not consider.
Yes, Lordship. Lordship, please to see.
Let us see 263.
263 order is at page
Income Tax Act
25.
25.
Section 263, page 1287.
Income
Lordship,
Tax Act pay.
book is different. Lordship.
Okay. 263, no? Section
263. Married Lordship. Revision of order prejudicial to revenue.
Yes.
263. The principal chief commissioner or the chief commissioner or the principal commissioner or the commissioner may call for and examine the record of any proceeding under this act, and if he considers that any order passed therein by the officer or the transfer officer, as the case may be, is erroneous, insofar as it is prejudicial to the interest of the revenue, he may, after giving SSC an opportunity of being heard, and after making or causing to be made such inquiry, he may deem necessary, pass such order thereon as the circumstance of the case justify, including an order enhancing or modifying the assessment or cancelling the assessment order and directing a fresh reassessment. An order modifying the order under section 92C. Lordship, here one subclause 1 will come into effect. Lordship, may come to page 25 of my memo of appeal.
Yes.
Page 25, Lordship. Annexure C.
Yes.
Order under
Annexure
section
B.
Lordship.
Annexure B.
Annexure
Page 25. The correct one. Okay, mine is written Annexure B.
maybe Lordship. I'm sorry.
The principal commissioner of income tax. At the top.
Yes, Lordship.
Correct.
Yes, Lordship.
Order under
Section 263 of income tax.
B out here.
Notice under section 263 was issued
10-1.
10/1/2019 proposing to set aside the order under section 143(3) dated 30/12/2016 on the ground of investment claimed by the SSC to have been made by Messrs. Topaz Solar Private Limited and Mr. Tilok and Income Private Limited was found to be not genuine, as these parties has denied having any transaction with the SSC company. 2. In its reply filed on 12/2/2019 by email, the SEC has objected to the proposed action under section 263 and submitted that since the assessing officer had treated the transaction as genuine on the basis of requisite details documents filed by the AO, now holding the transaction as not genuine is based in law. Thus, the order of AO cannot be treated as erroneous and prejudicial to the interest of the revenue. SSC further contended that it has not given the document relied upon to satisfy the assessment proceeding. It's seen from the record that the assessment was completed subject to verification of the areas investment made by the certain companies in share capital of the assessing company. In fact, the impugn order dated under section 143 3/147 dated 30/12/2016 addition of 13.1225 crores have been made under section 68 with respect to alleged investment by two other companies that were found not genuine on the basis of report of the jurisdictional assessing officer of the two companies, which fact has been duly confronted to the SEC. These facts are borne from the record of the case. Thus, the allegation of SEC that the things are happened behind the back or that the AO had accepted the investment in its share capital as genuine is factually incorrect. Next page. The SEC has relied upon various case laws to claim the assessment made on the basis of materials before the AO accepting certain facts claims cannot be reopened as cannot be held as erroneous or prejudicial to the interest of the revenue. Firstly, the claim of the SEC that the order accepted the investment by Topaz Solar Limited and Tilok Vincom Private Limited.
That the order accepted, which order accepted?
Lordship, the contention of the SEC that assessing officer accepted the contention of the SEC
Okay.
with respect to two companies. Then Lordship and Mr. Tilok Vincom genuine is finally incorrect. As pointed out in the above paragraph. Secondly, there is adverse evidence against the SEC that the denial by these companies or having any investment in share capital of the assessing company. This evidence need to be confronted to the SEC and the claim of the SEC re-examined in the light of the new facts that has been emerged and the facts of the evidence that SEC may like to submit further in this appeal. This would also take care of the grievances of the SEC that it has no knowledge of the evidence against the matter. The scope of this proceeding under section 263, the present case is merely to examine the evidences is now emerging with reference to the claim of genuineness of the investment in share capital of the SEC company made by Topaz Solar Private Limited and Tilok Vincom Private Limited. There is no other issue. Certainly, the SEC cannot have any legitimate objection to the opportunity so provided to present its case before the AO. Accordingly, the assessment order dated 30/12/2016 passed under section 143(3), that with section 147 is set aside to the extent of examining the genuineness of the alleged investment in the share capital of the SEC company claimed to be made by Topaz India Limited and Tilok Vincom shall confront the evidence of the SEC. The SEC shall file reply within 30 days of receiving the evidence of AO, and AO shall pass the order, revised order, after considering the reply evidence.
So this is the first round. This is the first round.
Thereafter, fresh assessment order was passed. Not page 27.
Okay, okay.
Without selling, Lordship, this order, they file appeal against the initial order, and that was satisfied.
No, so on the basis of this order of the principal commissioner,
Yes, not.
it assessing officer again made an order, correct?
Yes,
Assessment order.
Yes, Lord.
Now that assessment order is at page 27.
Yes, Lord.
And then they again went to the, then they went to the
Tribunal,
tribunal.
No.
Challenging which order?
earlier order.
Challenging
Let's me please to see page 30.
challenging the earlier order.
Not so.
And there was this second order brought to the notice of the tribunal.
Not see. No, not so.
And why didn't you also
Yes.
bring it to the notice?
Not see if it is, no, I'm sorry, Lord, see if it is there. Lord. Page 31.
Yeah.
Page 31.
Where?
Lordship, fourth line, pursuant to the notice. Lordship, from top, fourth line. Pursuant to the notice of the learned PCIT, the SSA replied where needed is object to the proposed action of the learned PCIT under section 263 of the Act and brought to the notice of the learned PCIT that AO has treated the transaction with these two companies as genuine on the basis of inquiry as well as the basis of requisite detail on and on support of the evidence on the relevant document. So the action of the AO in score cannot be faulted.
So the action of the AO on this score cannot be faulted means which part?
Second,
second order.
Second order.
So they're challenging the second order.
Lordship, no, Lordship, they file, Lordship, may please to see the opening.
But then this, so if the second order is, if the second order cannot be faulted, where is the question of going back to challenge the first order?
Lordship, they challenge the first. Lordship, may come to page 30. The first paragraph.
And the second order date is 38/2019.
Lordship,
No,
Lordship, second order is
38. Yeah.
21 to 2019.
You see, what is the order of the first order? What is the date of the first order?
Lordship. Thirty 12/2016.
30/12/2016. Where is that?
Lordship, page 20.
And second order is
Second order is at page 25. It is dated 21 to 2019.
you see the first order
Lordship,
of 30/12/2016 has been issued by the assessing officer.
yes, Lordship,
Assessing officer.
Lordship,
Now, this 21/2/2019, 31/12, is it?
it was by
31
PCIT, Lordship.
31/2/2019 has
Yes.
been issued by whom? PCIT.
PCIT.
What I'm saying.
PCIT
So
under
where
six.
is the second order issued by the assessing officer?
Lordship, page, because Lordship, the PCIT remanded the matter.
I know, that is why I remanded the matter to the assessing officer again.
Yes, yes.
Where is the assessing officer's second order?
Yes, page 27. Lordship.
See, that's what I want. So this is not the second order.
No, this
This
is
is the
not.
PCIT order.
Yes, PCIT.
PCIT order is different.
Lordship, page 27.
27.
Lordship.
Page 27 is the second order.
Yes, order dated 38/2019. 3/08/2019. See, after going through the record, the assessing officer made addition to rupees 13.2 crores. Lordship.
Now you come to the tribunal
Tribunal, Lordship.
order, page 30.
Page 30. Lordship.
This is an appeal
This is an appeal.
preferred by the against the PCIT order dated 21/12/2019, not against the first assessing order,
It is Lordship.
and against the PCIT order.
Date is incorrect.
Incorrect.
Lordship.
What is the date? It should be 02, that's all.
02.
Hardly any difference. So 02. So you mean to say, so what is wrong? It has challenged it has challenged the tribunal order.
Lordship, here, our contention is that
PCIT order has been challenged. So but then it has also taken notice of the second assessing officer's order, correct?
It is there. The finding of the tribunal is at page 35.
Yes,
Let's say below. 10 lines from below.
yes,
PCIT to issue the SCN proposing action under section 263 of the Act. The learned
where, page 35.
page 35.
Where?
Last 10 lines from below.
We note, does it start from we note? How does it start, the sentence?
Yes, yes, we can read from here. We note that despite the assessing asking for the information which enable the learned PCIT to issue SCN proposing action under section 263 of the Act, the PCIT has not furnished a copy of the same, which omission itself makes the impugn order fragile for violation of natural justice. And the learned PCIT in the impugn order has nowhere found the order of the AO to be erroneous, as well as the prejudicial to the revenue. After careful perusal of the assessment order, we are of the opinion that the AO has inquired into genuineness of the shares subscribed by swapping barter of the shares with 15 shareholding companies, including Topaz and Trilok. Therefore, the PCIT has to interfere, and then he was duty bound to demonstrate by conducting inquiry by himself to show as to how the AO has erred while conducting the inquiry.
Okay. So basically, right now, so you're challenging
Yes.
whether the decision made under section 263 is justified or not.
Yes,
That's
sir.
the basic thing anyway.
This is the best.
So anyway, what we'll do, we'll give one chance for them to appear. Otherwise, we'll decide the expert.
Lots.
No? All right, I heard Mr. Ezekiel, Leonard Counsel for the appellant, Income Tax Department, who submits that the impugned order issued by the tribunal, by the learned tribunal on 28/10/2021, is it?
Yes.
28/10/2021. In ITA number 464/GAE/2019. Under section 263 of the Income Tax Act 1961. He also submits that notice has been served upon the respondent by way of newspaper publication. And in this regard, an affidavit dated 19/6/2025 has been submitted. We have noticed that notice was issued, notice has been issued earlier by this court. By registered post with AD on 27/9/2020, no, on 27/9/2020. The notice had been returned back with a note stating, inverted commas, addressee cannot be located. Subsequent to the above, notice was published in the Anand Bazar Patrika. Huh. At
Some Tribune and as well as in
at Assam Tribune dated 12/12/24 and Anand Bazar Patrika dated same
notes, same.
day. However, no one appears for the respondent. Notice deemed to be served upon the respondent. This is the matter. 2 weeks. To enable the respondent to appear before this. In the event the respondent does not appear, the matter may be decided ex parte.
Much.
This is the jail appeal.
Yeah, appearing for whom?
I'm appearing for the accused person who has been
Okay,
convicted.
you are Miss M. Pathak.
I'm Pathak.
Okay, right. Miss M. Pathak appears for the appellant, while Mr.
R.R. Posik.
R.R. Kaushik appears for the state. As the TSC has arrived. TCR has arrived. They have registered to prepare the paper. This is the matter after 4 weeks. I just think the matter pertains to conviction under section 6 of the POCSO Act.
Lord Ship, this appeal was admitted on 4/6/2025
Yes.
on two substance question of law. One learned man is appearing for sole responding. Lord Ship, we hear the matter on their boss.
Basically, two issues out here.
Yes, Lord Ship, two issues.
Before my learned senior
Yes.
starts,
Uh,
my lord, my lord, 699 grams of gold was seized, from my possession.
Seized when?
See, on my lord, 24/1/2020, my lord. But, my lord, and the allegation was that these golds are foreign origin. My contention is I'm a jeweler, my lord. I came here to exchange and I have
Jeweler from where?
from Calcutta. But that is not
But you're a jeweler from Calcutta, you came here to Guwahati.
yes, I have
And it was seized where?
in Guwahati railway station.
Guwahati railway station.
Not by the customs, by the railway
GRP.
police, GRPS, my lord. But that is not the issue in this. Why I have started, my lord. Because I have submitted, the bills were submitted, everything is there, my lord. Only on the basis of the size, they are saying, on size and shapes, they are saying these golds are foreign origin, no foreign markings or nothing. But that is not the issue.
Is it a requirement that foreign gold should have foreign markings?
But something should be there, man.
No?
But that
You go to Bangkok, where does it say that this from Bangkok?
My lord.
Where does it say
Blankly,
that?
my lord. But that is not the issue, my lord. As per the valuation of the goods seized from my possession is 27 lakhs 90,000, my
No,
lord.
before that, you see there are two issues.
Huh.
One is that whether it has foreign marking or not.
My
I don't know whether foreign marking, just because there is absence of foreign marking,
my
whether it can be said that it is not smuggled.
my.
That is one.
Not my case is not also that.
Number two,
My
with regard to purity. Now, to be gold, does it have to have a certain benchmark, a certain purity?
yes,
How much?
my lord. The gold from. Can I submit before that one submission, my
Is it?
my lord? These are issues are there, but this in this particular way, those are not issues.
Okay.
Because the gold seized from my possession is 27 lakh 90,000 man. And as per Union of India, my lord, revenue cannot file appeal in High Court where valuation is less than 1 crore. There is a notification in the
Yes,
subsequent.
notification is there,
Then
but Lord
Well,
Ship,
they cannot file, my lord. Only to because Chested, they could not.
are you bound by the circulars that are issued?
Lord Ship, yes,
Then
we are bound by that circular, but here is the Lord Ship, the seized goods was gold.
Oh.
And under section 163, if it is smuggled, there are judgment of
My-
there are judgment of different high courts. In Meghalaya High Court also said that when the gold is involved, the litigation policy will not come into play.
no,
They can be seen.
It is there, Lord Ship. Policy is there, if the value is,
this is a division bench judgment she's showing me. Just let us see.
Lordship, that point was not argued before the Honorable Division Bench also. Now, subsequently, some judgment has come. When the gold is smuggled goods and it is proved by the department, then litigation policy will not in contact.
Anyway, let us see. Let us see.
My lord,
You are not allowing each other to speak.
I'll see.
So this is the question, Lordship, yes, it is correct, the value is below 1 crore. But in Lordship section 123 of custom act, Lordship, I want to place that. It is the burden of the SEC to prove Lordship, section 123 of the custom act.
Yeah, I should give this, the whereas and all in beforehand so that they are prepared. 123,
123 of the custom act.
yeah. Yes,
Burden of proof in certain cases. Where any goods to which this section applies are seized under this act, the reasonable belief that they are smuggled goods, the burden of proving that they are not smuggled goods shall be in case where the such seizure is made from the possession of any person, one, on the persons whom the possession of the goods were seized. Then Lordship, section 2. The section shall apply to gold and manufactured thereof, watches and any other classes of goods which the central government may by notification in the official gazette specify. So in case of gold, it is a burden of the person from whom possession the goods has been seized. Now, Lordship, yes, the question raised by my learned friend is to be decided by your Lordship, whether in case of seizure of gold, whether litigation policy
have you got this order?
yeah, it is, I was there, Lordship.
You are there.
Yes, Lordship.
So out here, it relates to seizure of gold.
Yes, Lordship, correct, Lordship. There are three judgments of this Honorable Court, Lordship. 7 appeals were filed by the department. So, this Honorable High Court says that when it is below 1 crore, then litigation policy will come. But subsequently, Lordship, there are judgment of different high courts.
But I am bound by this High Court judgment, not by other High Court judgment.
Lordship, but this is the position, Lordship, may please to hear and to decide, Lordship.
No. You see, the thing is that there has to be some uniformity.
No, Lordship, correct.
When a coordinate bench has already passed an order, how can I now rely upon some other High Court judgment and say our High Court
Lordship,
division bench will not apply?
I may be allowed
How-
to. Lordship, yeah, I understand, Lordship.
Predicament.
Yes.
Yes.
No, Lordship is correct. I am not disputing that.
Then
But in case of gold, the section 123, it is their burden to prove.
why don't you go against? Why don't you go to the?
Let's say we cannot go on to the Supreme Court because due to this problem, because Supreme Court's value is about more than 2 crore.
No, but then why don't you go in review against this order? You see, out here also, it's a question of seizure of gold.
Lordship. Yes, Lordship. it is-
And when Customs Act is involved, it only is in relation to duty, import, export. Correct? There's no other.
No, smuggling is,
Export.
no, it is,
Smuggling, whatever,
yes.
but import, export.
yes, Lord.
Trading inside India
In the-
is not covered by the Customs Act.
Lordship.
Correct?
Yes.
Am I correct?
Yes, sir.
If I'm correct, now what is there to decide?
Lordship, allow me 2 or 3 days, I'll search if there is any judgment of Supreme Court on this.
My lord, may I? My lord, I have given the notification by the Union of India. And that notification is not under challenged in the apex court.
Lordship,
So
this is
how
our
was it?
policy. We are not disputing.
They can-
Lordship.
It is the policy
My lord.
undertaken by them.
My lord,
It is not that they cannot overturn their policy
Right.
or make a new policy.
my lord.
Only thing is that this policy has been acted upon by the coordinate
Right.
bench of this court.
My lord.
And now I am bound by the decision of the coordinate bench.
Lordship, correct.
We are bound by it unless we take a different view and decide that it should be decided by a bench strength of more judges than 2.
So my endeavor will be to satisfy your Lordship that this order can be
No. Sorry. Justice Unni Krishnan Iyer is still here.
no, Lordship, there.
So you go and file a review.
My lord.
How can we go into?
If Lordship come to a
You go to,
conclusion,
you go to review. That'll be the most proper thing. Then the Chief Justice will constitute a bench comprising of Justice UKNR and another
so
judge.
that is,
That is that is the best thing to do. Others, how can we go into this question?
no, Lordship, correct, Lordship, I
No,
understand.
no. So uh, so we can say that we are closing this matter on this, or you say that you may file a review.
Not. Not.
Right. Right. What is the other High Court saying?
Lordship, in case of seizure of gold, litigation policy will not come into before the department to file appeal if the value is less.
If there is,
But Manipur High Court is accepted that notification. That they have not considered the judgment of Meghalaya High Court.
Meghalaya High Court has said that,
Yes, it can be filed. If the value is
passed by whom? Judgment passed by whom?
Lordship Chief Justice and
Which is,
Justice I.P. Mukherjee and Justice Dingdo. Lordship, this is a it's a small judgment of Honorable Supreme Court. And Lordship, actually, I've just before coming to court, Lordship, I've got this very small order.
It may be so.
But Lordship, Manipur High Court has taken different from the Meghalaya High Court.
actually, there is one point. It's the question of this, the policy followed by them. In regard to this appeal, is in the normal court. But when there's a question of smuggling, how should it be covered? Why should it be covered? Because it's not only a question of revenue,
Mine,
it is a question of smuggling,
mine,
legal act.
mine. So my lord, I have given two judgments by our High
By
Court.
our
Our High Court, two judgments I have given. One is
On the same line, Lordship.
custom reference 1 of 2024 and another is custom reference 2 of 2024. So the view is, my lord, if the question is above 1 crore, my lord, then the question of flex and because there is a notification by the Union of India. So those questions are not
You see, those could be, but let this policy.
my lord, I have given the notice.
Lordship, there are some exception to that also, Lordship, that will be written.
In all the cases on our Honorable High Court, I have appeared in many cases, my lord. All the same view has been taken. Only two I have shown to them. Many cases are there. My learned senior has also appeared on all the cases. When it is more than 1 crore, then the question of will arise and some of them went to Supreme Court, Honorable Supreme Court also. The similar, no, I have not, but on the monetary, the personal, there I did not appear, so.
Huh?
Those cases I have not appeared. In our High Court, I have.
But then from where did you read? Where did you get the information that Supreme Court has declared? You find in your dreams or you find
Online,
something?
but all the cases our High Court has.
See, well, this is a very simplistic way of looking at it. Doesn't say that it is incorrect. But the other aspect of the matter is when there is some illegal act,
Right.
when there is smuggling is allegedly involved.
Right.
Can we say that the monetary limit imposed by them would also have to be, would also cover smuggling?
Well, those,
That is point that might have to be decided.
my lord, in appropriate case, my lord, where my lord,
Okay, also, why is it not an appropriate?
my lord, where valuation is more than 1 crore, my lord.
Oh.
It is,
If you see, when it relates to, yes, but the problem is your circular also is so vague. Everything is covered. There's not, it hasn't made a distinction between smuggling cases or it just says revenue. Is it revenue? What is not the word used?
yes, my lord, revenue.
Some exceptions are there.
No, on the
Monetary
notification, no, monetary revenue. It is clearly said the revenue shall not press any revenue appeal in the high courts wherein monetary implication does not.
Whether- So this is not a revenue matter.
My-
This is not a revenue matter. I mean, this is
Smuggling of gold.
smuggling of
Right.
thing and non-payment of duty.
duties. My lord, this, the custom reference number 3, my lord, where,
All for permissions custom preventive. Specifically,
my lord, my lord, also, my lord, may kindly see for a moment, my lord.
or basically, what is without payment of actual duty, correct?
GST and other taxes. So,
Have you been charged under the, have you been charged for smuggling?
my lord, 123 customs, all cases are 123 customs, the betel nut custom, wine and all the cases, not only gold. Gold is not an exception. The money, my lord, may kindly see for a moment, custom reference number 3, my lord, the judgment I have given. My lord, para number 6 below. The last page number 6.
Number 6.
My lord, Allahabad High Court also have
Para number 6.
6 below, my lord.
Yeah.
Allahabad High Court also, my lord, custom appeal number that has been followed. Allahabad High Court also has taken the same view, my lord, on the monetary limit. Exceed 1 crore, then the questions will be there.
Okay, so 123 burden of proof, okay? Now, okay, supposing they are not able to prove that it was not smuggled, then what is the consequence?
If it is not smuggling goods, if it is held by the authority, then the gold has to be released in his favor.
And if it is proved that it is smuggled goods, then
Then it will be confiscated and fine will be imposed on him.
or
Lordship,
to be paid, what? Immediately be paid.
Lordship, if they prove the documents that it was properly imported from other country, then they are liable to pay tax.
Where is that? Show the
Lordship,
provision.
page 37,
Where is the section?
Lordship. Section 11H. Chapter 4B.
What?
Lordship, there is a definition
How?
of illegal export. Section 11HA. Illegal export means the export of any goods.
Hey.
H.
11 2H. Maintenance of standard.
Lordship, here chapter 4B.
Yes.
Illegal import. 11HA. Illegal import means export of any goods in contravention of the provision of the act or any other law for the timing and force. The intimated place means a place intimated under subsection 1 of section 2 of subsection 3.
So this is not export.
It is not export, it
Then
is
where
David.
into play? You have not seen this outside India.
It was, yes, it is seated in Guwahati, Lordship, in the railway station by
Then-
GRPA.
But how can you say it is illegal export? then?
And also they have not seized, my lord. Assam police
No,
has.
that are done.
Lordship, they were charged for possessing the foreign goods. In paragraph 36, page 37.
You're not sure of what you're saying. One thing is that at the end of the day, we have this. Again, we're stuck with them. Can the SSC be, I mean, the person be sentenced to jail or something? No, there's nothing.
Criminal provision is there.
That's a separate.
That is the
provision.
separate.
That's a separate provision.
That is separate.
You follow that out here, so this is only monetary,
Both proceeding can be initiated by the department.
but so this is for monetary purposes only.
Here, Lordship,
I'm not saying my learned senior, but the department, because Calcutta, they could not prove. Now they have to refund, so monetary, within monetary limit also, they have filed just to delay money.
You go to Supreme Court, you can, that,
no, that point is, Lordship, probably smuggling part is,
Smuggling part is the criminal part, no?
no, Lordship, here, if we prove
That
that,
they have got to prove, but the problem is the monetary value, what to do.
no, that is there, Lordship. But
Already-
but my submission is that, Lordship, in case of smuggling of gold, probably this limit will not come into bar for the department to prepare. the-
Why don't you take it up with your
Lordship.
authorities?
That is there, Lordship.
Right, third Mr. S.C. Katz, Learned Standing Counsel for the Customs. Back to repellent. Well, by the counsel for the
Appellant.
appellant, for the appellant, bracket customs. Miss
SSGF,
S.S.
GF.
Jia appears for the respondent. The matter pertains the seizure of how much? 167,
699.310.
699.310 grams of gold
Gold.
in the Guwahati railway station by the Railway Protection Force personnel, and which was handed over to the Customs Department by the Customs personnel. Yes, sir. The appellant is in appeal against the impugned order
Lordship.
dated impugned order dated
Lordship. 15/1/2020.
2025,
Lordship.
passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, in Customs Appeal number 75449 of 2020. By which the gold has been confiscated, seized gold has been confiscated, and a penalty of rupees 2.8 lakh has been imposed upon the appellant. The appellate tribunal, the learned appellate tribunal, in the impugned order dated 15/1/2020, had held that there was no evidence to prove that the gold that had been seized from the respondent were of foreign origin and that it had been smuggled into India. It had also held that it is a gold was seized at the outskirts of Imphal.
No, Lordship, in Guwahati.
What is this wrong?
Lordship, page 22.
At page 12 of the at page that is different.
This is different.
That is different.
That,
That is
some
different.
judgment.
Okay. Wait, huh? It has held what? Different. The above decision had been made on the ground that there was no foreign marking on the gold and that the purity of gold was 99.30 to 99.39%, for which gold could not be confiscated. As the conditions of section 110 of the Customs Act had not been complied with. There was no evidence to prove that the seized gold was of foreign origin. The learned appellate tribunal thereafter directed that the confiscated gold should be released back to the respondent. And the penalty was also set aside. The learned counsel for the appellant submits that though there is a standing instruction F full stop number full stop 390 NO number slash miss slash 116 slash 2017 dash JC dated 22/8/2019, which bars the filing of appeals in the High Court by the Customs Department, which is to the limit of 1 crore, comma. The said policy of filing appeals cannot cover cases involving smuggling of gold. Correct? Next para. On the other hand, the learned counsel for the respondent submit that as the monetary value of the alleged smuggled gold, seized gold, alleged seized gold is rupees how much?
27 lakhs and what? 27 lakh.
27, comma,
Notes.
90,200.
3, comma,
247.
47, comma. The appellant could not have filed an appeal in this court in violation of its own policy, appeal filing policy. In support of her submissions, she has relied upon the decision of the division bench of this court in a batch of cases, the leading case being CUS full stop REF full stop /3/2024 bracket Commissioner of Customs bracket preventive versus Sahib Jain, SAHIB Jain, which was decided on 19/2/2025. On the other hand, the counsel for the appellant submits that the Meghalaya High Court in the case of the Commissioner of Customs bracket preventive versus Dalit Kumar Verma and others. CUS APP number 1/2024. Has held that the notification giving the monetary limit for filing appeals before the High Court in cases relating to smuggling would not cover. Oh, no, whatever I said, agreed. The last sentence. Oh, no, would not cover cases relating to smuggling. Where orders for confiscation and imposition of fine are provided. We have heard the learned causes for the parties. As can be seen from the judgment of the division bench of the High Court of Meghalaya. Cases involving alleged smuggling, cases involving smuggling of gold would not be covered by the notification issued by the Ministry of Finance, Department of Revenue, Central Board of Indirect Taxes and Customs. To High Court, if the monetary limit crosses 1 crore. Does not cross 1 crore. If the monetary limit does not cross. However, the division bench of this court in various cases and in various cases has, on the other hand, held that or this High Court has by taking into consideration the decision of the Allahabad High Court rendered in Custom Appeal number 1 of 2022. Has held that the challenge made to the challenge made by the Customs Department with regard to alleged smuggling of gold would not be maintainable if the monetary involvement was less than ₹1. As the present matter relates to alleged smuggling of gold, having the value of ₹2790. We are of the view that the decision of the division bench of this court passed in custom reference 3 of 2024 and others would have to be. Applied to the present case. As we are bound by the decision of the coordinate bench of the and not by the division bench of another high court, if there are two conflicting views. Consequently, the appeal is dismissed. Okay.
Item four.
Yes, item 4.
Item four. My name is not reflected. My name may be,
Where is your Wakalat Nama?
no, I am the legal aid counsel.
Huh?
I am the legal aid counsel.
Your legal aid counsel. Where is your appointment letter as a legal aid counsel?
In this case, my lord, we are
appearing
appearing as legal aid counsel, my lord, again. But our name does not reflect in the daily cause list. my lord.
You are appearing as what?
Legal aid counsel, my lord.
Where is your appointment order?
It's here, my lord. My lord, we have annexed it in the delay condonation petition, my lord, but not with the appeal.
Oh, okay. And this-
Delay was allowed, my lord, now it
That
has
will be
come
there.
for admission hearing. Oh, it's there. My lord, in IA, your lordship will find, my lord, IA number 927.
There. This thing like that. It will- but yeah.
927
Yes,
पर दिया है सर
Okay, fine.
अब
Heard Mr.
vacation
BK Sen. Learned Legal Aid Counsel. This is an appeal against the judgment date
8/1/25
8/1/25.
passed by learned
Just a minute, Mr. Counsel,
My-
that much
my-
I will do. Passed by the special judge Chirang at Kajalgaon in special POXO case number 5 of 2024. Arising out of Sidley PS case number 15 of 2023, comma, by which the appellant has been convicted under section 6 of the POXO Act. Admit the appeal, call for the TCR, issue notice to the respondent, returnable in 4 weeks. Mr. R. Kaushik accepts notice on behalf of the state. Then the same thing, regarding that. Registry to. This is the matter out of service. Then in the IA, there's IA.
my lord.
In the IA, is this one, give it back to me. Mr. Counsel, I think you have got to file a fresh application. What is this? Say, you're asking for bail under section 389 of BNSS?
My lord, I have corrected it, my lord.
What?
I have corrected it, my lord. This is
How have you corrected?
my lord, in the office I was, my lord, told that, my lord, it should have been 483.
Mr. Counsel, bail can only be granted after the sentence is suspended.
Yes.
You have got to file an application under section 4302, 430, bracket 2.
But suspension and
Yes, only then. You withdraw this, you file a fresh application, application is wrong. And there's no correction here also. Okay, Mr. BK Day, learned counsel for the, learned legal aid counsel for the applicant, submits that he may be allowed to withdraw the application and submit a fresh application for suspension of sentence and bail. Mr. R. Kaushik appears for the state. The prayer of Mr. B.K. Day is allowed. I is accordingly dismissed as withdrawn, with liberty of state. B.K. Sen. B.K. Sen.
My lord, our name may kindly be shown in the.
Registered to reflect the name of Mr. B.K. Sen, legal aid counsel in the causeless.
Obliged.
May I please, your lordship? Lordship, I am appealing the legal aid counsel in the matter. This is an appeal against.
Sir,
victim.
Mr. U. Chaudhary, learned counsel for the appellant, who submits that the judgment dated 28/6/2023 passed by the Sessions Judge Shivsagar in Sessions case number 213 bracket S-S bracket close of 2014, arising out of Amguri PS case number 176 of 2013, by which the appellant has been convicted under section 302 IPC, should be set aside. Admit the appeal, call for the LCR. Mr. R. Kaushik, additional PPF for the state. List the matter after 4 weeks.
Lordship, there is an I also.
Then in the IA, right, Mr. R. Kaushik is granted 4 weeks' time to file an application, to file a written objection to the application made under section 430 BNSC. This is the matter of the phone.
Obliged.
Heard Mr. L.R. Mazumdar, learned counsel for the appellant, who submits that the judgment dated 29/5/2024 passed by the Session Judge Karimganj in special NDPS case number 124 of 2022, by which the appellant has been convicted under section 20 bracket B bracket Roman 2 small bracket C small /25/29 NDPS should be set aside. Issue notice, admit the appeal, call for the PCR, issue notice returnable in 4 weeks. Mr. R. Kaushik accepts notice on behalf of the state. This is the matter after 4 weeks.
Lordship, there is the idea.
I write Mr. R. Kaushik, additional PP is granted 4 weeks' time to file an an objection to the application made under section 430.
Lordship, it is 389
389 what?
of CRPC. Sorry, Lordship, 43. Right.
Huh?
43.
You wanted 389,
Sorry,
give
Lordship.
me- let me clarify now.
Yes.
430.
All.
4 weeks. Same thing. So file a written objection to the application under 430 BNS.
Fine.
This is the matter of the 4 weeks.
Yeah, please, your lordship. This appeal against conviction, yeah.
Huh?
Appeal against conviction, judgment.
Okay, right. Heard Mr.
T. Boraman.
D. Bora, learned counsel for the appellant,
My lord.
who submits that the appellant has been convicted under section 4 bracket 2 POCSO Act, while the other co-accused who are not appellants in this case have been convicted under section 342/232, 323/34 IPC. He submits that the judgment dated 11/7/2025 passed by the special court Charadio Sonari in special POCSO case number 3 of 2019, arising out of Moran Hart PS case number 2 of 2019, should be set aside, insofar as it relates to the appellant hearing. The appellant, White Raman, you write, huh? WHITE Raman.
White.
Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Mr. R. Kaushik, additional PP accept notice on behalf of the school. Then the applicant shall furnish a soft copy of the appeal to the office of the PP, who shall thereafter forward the same to the OC of the concerned police station, for service of notice to the respondent number 2. A report shall thereafter be furnished by the OC of the concerned police station to the PP.
There is an I also, my lord.
This is the matter after 4 weeks. Then in the IA, you write, Mr. R. Kaushik, additional PP is granted 4 weeks' time to file written objection. The application under section 430 bracket 2 BNF. This is the matter of the 4 weeks.
Obviously.
Heard Mr. J. Ahmed, learned counsel for the appellant, who submits that the judgment dated 5/6/25 passed by the additional sessions judge special judge bracket POXO, Morigaon, in POXO case number 123 of 2024, arising out of Morigaon PS case number 299 of 2023, by which the appellant has been convicted under section 6 of the POXO Act, should be set aside. Admit the appeal, call for the TCR. Mr. R. Kaushik, issue notice returnable in 4 weeks. Mr. R. Kaushik, additional PP accept notice on behalf of the state. Then you write the appellant shall serve a soft copy of the census. Same thing, huh?
I is there.
You write Mr. R. Kaushik, additional PP is granted 4 weeks time to file his written objection to the application under section 430 BNS. This is the matter of the point.
May it please also.
Yes.
As per the last office note, notice has been served upon the respondent number 2 to the OC.
Has been served?
No, as far as the way.
There's
that
nothing
they-
there. Yes, he has supposed to give the report.
Yes. And the
No office
drafting
note.
worship.
Steps were taken
Please
to the, I'm sorry, madam, steps were taken to the OC.
Yes, madam.
Worship, 10 days time,
Yeah, you need
my lord.
Miss B. Boyan, additional PP
When I know
is
copy,
granted up
copy.
the 10 days time for further instructions as to whether the OC of the concerned police station has served notice upon the respondent number 2. As paperwork has arrived, registry to prepare the paperwork. TCR has arrived.
It's arrived.
The registry to prepare the paperwork. This is the matter after
Service of notice. now.
4 weeks. To file written objection. 4 weeks time,
As well as to submit the service. report.
as well as to submit the service report as to whether notice has been served upon the respondent number 2 by the OC of the concerned police station. Then in the appeal you write, as TCR has arrived, the registry to prepare the paperwork. This is the matter of 4 weeks. I put it in both. You put this order in both, I think.
May I please, your lordship? I thought I am appearing as
Miss
PB board.
Bordula, learned legal aid counsel,
Only 94 days.
the
delay.
applicant she submitted that there's a delay of 94 days against the 94 days in filing the appeal against the conviction of the appellant under section 6 of the POCSO Act. Ms. Bilboyan, additional PP submits that she has got no objection to the delay being condoned. So accordingly, the delay of 94 days is condoned. Appeal be registered and listed after a week.
Highly obliged.
Mr.
I'm Arsan on behalf of K.R. Borua.
Mr. R. Sharma appears on behalf of Mr.
K.R. Borua,
Sarwa. Learned counsel for the,
DLS. He is DLSA counsel.
learned counsel for the applicant.
Yes.
We submit that there's a delay of 286 days in filing the appeal and the section, filing the appeal against his conviction under section 302 IPC. Ms. B. Boyan,
Yes.
same thing, huh? No objection.
My pleasure, Your Lordship.
Yeah.
In this matter, before going to the merit, my lord, I have raised a query regarding juvenility of this accused now.
The?
Juvenility issue. There is a report from 14th August 2023 from the additional district judge, my lord.
Where is it?
Probably it is flag
Green
A.
colored flag, Your Lordship.
flag A of the
Green
court report, my. Flag A marked as A.
No, we should follow this.
The birth age has been discerned on the basis of the original, on the basis of the birth certificate, is it?
Medical register.
Medical register.
Of the garden.
Now, what does section 94 say? Juvenile Justice Act 2015.
May I read, ma'am? The presumption and determination of age where it is obvious to the committee or the board based on appearance of the person brought before is under any of the provisions of this act. Other than the purpose for giving evidence that the said person is a child, the committee or board shall record such observation stating the age of child as nearly as may be and proceed with the inquiry under section 14 or section 36 as the case may be without waiting for further confirmation of age. Number 2, in case committee or board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board,
So,
if available.
here, that this is not covered by that.
by 1 month.
Then next,
The birth certificate given by the corporation or a municipal authority or a panchayat. This is also not covered. Ma'am.
no cover.
Then third, and only in the absence of 1 and 2 above, age shall be determined by an ossification test or any other latest medical age determination test conducted on the orders of the committee or the board. Provided such age determination test conducted on the order of the committee or board shall be completed within 15 days from the date of such order. So he was never placed before any board or committee minded for determination of age. In fact, that issue of juvenility has not been raised in the entire proceeding, my lord,
Okay, can be raised
at any point of time. my lord.
only problem now is that the manner in which the age has been supposedly proved
My
is not covered in terms of that section 94.
1 and 2. 3 is there.
So the only thing, I think the best, the only way to go forward
My lord.
is to maybe have an ossification test,
My lord.
or it has to be done as per 94, I think. But incident occurred when?
Date of occurrence? Incident 18/9/16.
18?
9/16.
18. I will have an ossification test.
Lordship, may I make a submission? Lordship may be pleased to take up section 34 of the Indian Evidence Act. Entries in books of accounts. You want to echo? Entries in books of account, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not be alone sufficient evidence to charge any person with liability. Lordship, then section 35, relevancy of entry in public record or electronic record made in performance of duty. An entry in any public or other official book, register or record or an electronic record stating a fact in issue or relevant fact and made by a public servant in a discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country in which such book, register or record of an electronic is kept itself is a relevant fact. Then another lordship 75 of the Evidence Act, my lord. 74 public document. What are public documents, my lord? Section 74. The following documents are public documents. Documents forming the acts or records of the acts of the sovereign authority of official bodies and tribunals and the public officers legislative, judicial and executive of any part of India or of the Commonwealth or a foreign country. Public records kept in private documents. Lordship, if I'm not wrong, my lord, this official records was produced by the officer concerned, the doctor, my lord. Oh, I have not gone through the deposition part. Maybe it's a part of the public document, my lord. And the officer himself come up.
Problem is that we cannot decide on the basis of maybe.
No, lordship, because I've not gone through. And the office has not provided me with this and the deposition. Senior medical officer, my lord. Lordship, senior medical officer, his deposition has been taken. It's a part of the inquiry report.
Look, this is the record of a tea garden.
Oh, this is not a government, then it not be. Because I have missed it, I have no copy, as I have not made this submission before the court date since the copy is not available. I've taken her.
Medical register of the garden,
Is a medical
but
officer,
register of the tea garden.
whether it's a government hospital, tea garden hospital.
By the garden hospital
Oh,
of Hundred Tea Estate.
Not the birth certificate issued from the authorities, government authority.
then in the event of the matter, your lordship may be pleased to give order for a notification if your lordship desires. I'm not aware of whether it's a
The
government
senior
hospital or not.
medical officer of Anuwal Tea Estate, Mariani Jorhat, Dr. Spencer was also summoned and he appeared
What is-
with the relevant register hospital record birth and. The senior medical officer,
Yes.
the original birth certificate appears to appear from principal. But this is of the Anuwal Tea Estate, whether Anuwal Tea Estate
State
is
is
the
a Government hospital.
hospital inside, there is the government hospital.
No.
Okay. Ah,
Hospital. In a particular.
Registered medical officer is a government.
Let's see what. See particular officer of that particular company. Of that particular. That. That. Hospital belongs to the team.
So may not be the government. So it, section 75 will not be applicable. In the event of the matter, your lordship may please to direct for a notification test if your lordship desires now. Similar view was taken, the Honorable Supreme Court. No matter. Similar view was taken since the record was from a private school. Honorable Court did not entertain. And the matter was a grievous offense, ma'am. Here also, lordship 302 and oral dying declaration is there.
yes, that all time, yes, yes. It
That
is
is-
proven. Proven, yes, oral dying declaration. He died soon after he died. No.
After 2 days.
After 2 days,
He came and I think he confessed before his
Yes, yes.
father, no?
Yes,
Told his
the
He was making for his father.
there is no such as confession, but everyone in PW, my lord, that relying evidences, they said he only informed that so and so has stabbed me.
What else do you want? What else do you want? You want that, wait, I won't die yet.
No, no.
Please bring camera, video camera, bring this.
Regarding fitness and all these things, nothing has been depicted from this judgment.
Anyway, is there any enmity between the parties?
No reason is stated. Cause of death, why he has stabbed, that is not come
There,
out.
eh,
Enmity
He
is not,
said it while he was alive. Why should he tell a lie?
that is true.
Supposing someone stabbed me, why should I pinpoint him? Yes, he did it.
Yes.
Why? Unless you are able to show that there's some enmity or something.
No, no,
Because it is a Damocles sword also. I mean,
no,
it can work both ways,
my,
right? Heard Miss B. Burman, learned amicus.
Amber,
Huh?
Amber.
M. Burman, and Miss B. Buyan, additional people for the speaker. The appellant has been convicted under section 302 I2 on the basis of a dying declaration made by the people. The appellant, having raised an issue of juvenility from a discord and directed the additional sections Judge Torhat to cause an inquiry with regard to the same. Consequently, the additional district and section Judge Jorha bracket trial court has issued an inquiry report dated 14/8/2023, which is to the effect that in terms of the relevant register / hospital record of the Hanuwal Tea Estate Hospital, Mariani, Jorhat. The appellant was born on 1/3/1999 and as on the date of the incident, that is 18/9/2016, he was 17 years, 6 months and 17 days. Okay. Next para. We have noticed that the age of the appellant has been determined on the basis of the register of a private hospital belonging to the Hanuwal, Hunuwal, Hunuwal, Marian, and not a government hospital. As such, it might not be safe to accept the date of birth made on the basis of the hospital, Tea Estate Hospital, in terms of section 35 and 74 of the Evidence Act. As the determination of age / juvenility has to be, can be decided in terms of section 94 of the JJ Act 2015. What is the full form?
Juvenile Justice
The
Care and
Juvenile
Protection.
Justice, within bracket, Care and Protection of Children Act 2015.
Next paragraph. Section 94 of the JJ Act 2015 states as follows. In view of the above reasons, we direct the additional district concession Judge Jorhat to cause an inquiry and make a determination of the age of the appellant in terms of section 94 of the JJ Act 2015. Even if it requires an ossification test. The additional district section judge shall ensure that the ossification test is conducted in his presence, his/her presence, and no, while taking the blood sample from the appellant. Just say his or her presence or representative's presence. Or representative. List the matter. When? Don't say not his presence, forget it. His and her presence. It will be done by the medical board.
Duly constituted.
By a duly constituted medical board. Okay, put it somewhere. Okay. The inquiry report should be made preferably within a period of 3 months. Or is it too long?
It would be too long now.
2 months or 1 month?
Within 2 months, no.
15 days deposit to the extent patient.
Right?
After months.
Otherwise, it
Within a
is 15
period of,
days.
a period of 6 weeks.
No.
So we should send back the report, the
Yes.
TCR.
Yes, ma'am.
Registry to send back the TCR to the learned trial court. Who shall thereafter return it to the
No.
registry along with the inquiry.
Okay.
List the matter given it.
Lordship, not only the blood, my lord, he has to take a radiological and a dental.
That's all. Or the, don't say blood, this thing, the medical. Classification.